Sam Seder, Emma Vigeland on the Majority Report. It's a pleasure to welcome back to the program Chris Geidner. He's an award-winning journalist and the Law Dork, publishing at the Law Dork on Substack. Chris, thanks so much for joining us. I think it's been several months, since we spoke last, and the State of the Union is not doing much better. In fact, probably significantly worse. But I want to go through some of these cases and then talk about the sort of like last time you were on, the general thrust of all these advocacy groups going in and suing the Trump administration, and to some extent, in some ways, overwhelming them in a very rather helpful way. But first, let's talk about this ruling that happened Friday night in L.A. A Judge Frimpong, federal judge in L.A., found that what ICE was using as reasonable suspicion to essentially pull over any brown people who might be, working as a gardener or some profession they think would be an undocumented immigrant profession, I guess. She put a basic a freeze on it for the time being.
Yeah, I mean, this is basically a stop and frisk case, except for with the results being an effort to assess the legal status of the people that they are stopping and frisking and arresting and deporting them. So it's sort of like stop and frisk on steroids. And the ruling was a temporary restraining order to stop that. And the Justice Department on Sunday already has filed a notice of appeal, which is going to go to the Ninth Circuit at first. And then depending on what happens there, I'm sure they will quickly run to their friends up at the Supreme Court with this.
Yeah, that's what I'm sort of curious about, is the sort of like, particularly in the wake of the naturalization case, I guess, ruling about and I still not sure I have a full grasp on what they held there that was applicable outside of this, but the limitations of something like this. So her order is just for California, or is it just for the LA area? I mean, it's not binding on ICE outside of.
The entire. Just applying to what they are doing in the lawsuit is about the Los Angeles efforts. So the only specific ruling that she is limiting it to is this this specific effort. It is an enforcement effort that I'm using effort because I don't know what other word I want to use right now, but and so it is a more limited ruling, even though there has been such attention on Los Angeles. But the effect would be that if you saw similar enforcement efforts elsewhere, they would certainly bring similar litigation and now sort of have a model of how to pursue this litigation.
And what are the safeguards against ICE just saying, no? Like, what happens under what? It seems to me that it's one thing to sort of say, like, okay, we want to enjoin them for using these practices. And in this instance, as opposed to like stop and frisk, the political calculation of that entity still using that stuff is not the same as like the New York Police Department, let's say, continuing to do that. under a city, where the mayor has a direct responsibility here. This is an outside force coming into LA. What are the remedies now? Are the remedies changed in the event that they are found to be continuing to use that stuff? Like, this is where we run into that problem. Like, you and what army is going to make us stop doing this?
Yeah, I mean, at the sort of end of the discussion, that would be the bottom line. But the reality is that DOJ, as I said, DOJ and DHS as their client appealed that order. So, there is, in some ways, I always look at appealing as even though that might annoy us, and even though that might mean we're headed back into the warm embrace of the Supreme Court yet again, it is in its way a sign from the administration that they are still accepting that ruling as legitimate and binding on them.
And so it goes to the presumably to the Ninth Circuit on appeal. Is there a chance that the administration fast tracks it to the Supreme Court? Because this is where we get into the shadow docket, where you would think then there's no reason for the Supreme Court to do this. It's not like, ICE is going to be prejudiced or harmed if they are not able to do this, for another 3-4 months or whatever it would be. But that's not the way the Supreme Court's been. They've been doing the opposite. They've been saying that it's materially harmful to the government to not be able to do this stuff so quickly and so violently, and for lack of a better term.
To enforce their Article 2 powers, that any infringement on the president's powers is irreparable harm. And we've sort of seen with, and I do think this is potentially the distinction when it comes to the sort of external factors, when it comes to things like the secretary ending status for people, when it comes to things like these third country removals, when you're taking somebody to a country that they never lived in, have no connection with, which is horrific on its face. But there is sort of when you're looking for potential distinctions, an argument that where the Supreme Court has been overly deferential has been to the external looking, the extraterritorial related decisions, and that potentially there could be a different ruling on something like this, where you are, as you said, talking about what effectively amounts to an invasion of a U.S. city.
So I guess we'll see what happens in that case. In the meantime, theoretically, at least, ICE should be somewhat constrained, I guess is the best. Yes. Constrained in the way that they operate there. Let's turn to.
I would just one last thing. I'd note that I do think we're seeing some interesting things happening with the Trump administration and the way they're treating the Ninth Circuit, because it now has. It's a huge circuit. It's like 27 judges. And the fact is that Trump did get a lot of appointees in his first term. And so when these things come up on appeal like this, they first go to a 3-judge panel. Right. And I think there is some hope from the Trump administration when they do appeal things out of the West Coast that maybe we'll get a good panel draw at first so that we won't even need to go to the Supreme Court. So I do think they will, to your question of whether they try to leapfrog the Ninth Circuit, I think they'll at least see who they get at the Ninth Circuit and see if they can get a ruling there.
And if they get a good ruling from a 3-judge panel, then the plaintiffs, again, I think it's the ACLU, would then go to an en banc. Right. The entire 27 justices, more or less, and look for a ruling from them. And then, okay, so just so people have a sense of like what could happen there. But that's interesting about, I didn't realize Ninth Circuit for them now is like a worth taking a gamble on, I guess. Let's talk about CCOT.
Yeah.
Abrego Garcia is back, but sort of being in a sort of like a limbo state, trying to avoid getting deported again to now another country. But there was also a big revelation about CCOT in a filing the other day. Tell us about that.
Yeah, I mean, we've been going through all of this litigation, and once this was established, that, I mean, because if you remember back in the beginning, we didn't even know where they were going. We didn't know what was going on. Then when we found out they're at CCOT, the argument that the administration has been making, and specifically before Chief Judge Boasberg in a class action lawsuit, the habeas action that is specifically about the people who were sent to CCOT under the Alien Enemies Act, but it's also come up in a bunch of other cases whenever judges issue orders, like in Abrego Garcia's case, to facilitate the return of these people. The Justice Department has argued, with a declaration from a State Department official, that essentially once people are sent to CCOT, it's El Salvador's responsibility, that they've taken the authority for these people. They're doing what they want. Anything that we do as the American government to get these people back is a foreign policy negotiation. It's diplomacy. And that's why they're arguing that, like, essentially the courts have to step back because diplomacy is like the height of the president's powers. But then there was this UN report filing in which the commission that got a complaint about the people who were sent there issued a report that said that El Salvador told them that they did not have the control over these people, and that in this context, the jurisdiction and legal responsibility for these persons lie exclusively with the competent foreign authorities, i.e., the United States. So that's what El Salvador told the UN, that this is essentially, we are letting them use our facility, but the US still has the final say over these people, which is shocking. And
this seems to be shocking, and like it would. And so how is that filing being addressed at this point? I mean, it feels like there's been concerted lying to the court, obviously to the American people, but directly to the court on multiple occasions. I mean, this has been going on for months, where they're
in
like,
multiple cases,
there's only so much we can
occasions. So the first sort of fallout from this, the document was filed before Judge Boasberg in this class habeas effort to get due process for the people sent to CCOT on March 15th. But in another case where Judge Stephanie Gallagher in Maryland is hearing a case over a settlement that essentially said the US government can't remove members of this class until they get a ruling on their asylum claims. But one of those members of that class was sent to CCOT on March 15th. He's been identified in the documents as Christian. And she, similar to Abrego Garcia's case, ordered the Trump administration to facilitate his return. Like with Abrego Garcia's case, they've been dragging their feet on this. And she issued an order the day after the UN report was filed in the DC case, essentially saying, government, tell me what's going on here. Explain this, explain how this doesn't contradict what you have been saying about this. And she gave them till July 15th, so tomorrow, to file their response as to that. And I think that she will hopefully not be the last judge to sort of call for this. But as we learned with Judge Zenas, who's still last week held a series of hearings over the way the Trump administration has treated Abrego Garcia, that all it takes is one federal judge to really stand on their ground and say, no, you have made claims to this court under oath. I'm going to call you to account for them.
Do you have a sense of the status of the other prisoners sent to CCOT in El Salvador? Like the hairdresser comes to mind, the man with the autism awareness tattoo, among others.
Yeah, I mean, as far as we know, they're in CCOT. We don't know if other people have been moved similar to the how Abrego Garcia was moved. We don't know. We did get another sort of bombshell that we got last week was, if you remember, this Irez, I forget his last name,
Right.
the State Department official who was the one who admitted in court what had already been in filings, that Abrego Garcia had been removed in an administrative error. Irez Riovini.
Right.
He was the one who filed the whistleblower report, and that went to the Senate Judiciary Committee, among others, because of the fact that the fact that we have the Emil Bove being nominated for the Third Circuit Court of Appeals, despite being behind a bunch of this. They turned over a bunch of their emails and texts last week. That was a really a smart move by Durbin. When that whistleblower disclosure came out, he followed up and asked the lawyers for the actual evidence behind it, and they turned it over, and he publicized that last week. And so we got a bunch of information that's truly damning on the front of sort of how the government sort of essentially implemented this with being aware that it might be lawless, with being aware that they might quickly be facing court actions, trying to get them to fall back, and still went forward with this. Went forward with, I don't know if like you've even heard about this, but there was like an effort for a week or so for the administration to get around Boasberg's initial Alien Enemies Act order by sending people to Guantanamo Bay and then having the Department of Defense take them to El Salvador. Like this is just, there has just been lawlessness after lawlessness, and we're almost in a situation now where courts are like Judge Gallagher did. They're acting, but it's almost having to slow down the wheels because the Trump administration acted so lawlessly, so quickly over the course of March and April.
It does seem like there is an attempt by the administration in this sort of like area to play with jurisdiction. Because I've also heard, one of the ways that they kept some of those lawmakers out of that detention facility down in Florida is by saying it's a state detention facility. So we can't,
it's not an ICE facility. It's a state facility. It's essentially they're arguing it's essentially just a state prison. And
this seems like a concerted effort across. I mean, the idea of like, well, if we get them to Guantanamo it's almost like we go through some type of like, it's laundering. They're basically laundering their prisoners. We're no longer associated with it. And the Defense Department does as the Defense Department does. It's no longer an ICE issue. I imagine this is going to keep happening, but I want to move over to the SCOTUS decision about the mass firings.
Yes.
In the federal government. Again, it's one of those things where it's like hard to call it a decision. It's just, I guess, an edict, because there is no sort of argumentation behind it. It's just, yeah, you're good.
Yeah, I mean, the way that the shadow docket has been used has been troubling, and that's why it's gotten this attention in recent years. But what we're seeing now is essentially shadow docket rulings, which, I mean, to be clear, we use this phrase, the shadow docket. What they are is like legally, they're emergency applications. They are before like 15 years ago, 90% of the time that you saw an emergency application, it was in a death penalty case. And that's why I've covered the death penalty now for 15 years. And I was like, I literally remember the time when like 90% of the cases we got on the shadow docket were just death penalty cases. But how they're being used by the Trump administration, especially in this second era, is to enable the Supreme Court to issue a ruling that it says isn't a merits ruling, that they say this is just on this initial first look at the case in order to figure out how it should proceed while litigation's going on below. But the bottom line is that first look is essentially resolving the case. When you look at I already mentioned the shadow docket rulings where they allowed Secretary Noem to implement 2 different actions that removed legal status from 500,000 people. Those people, especially now in this administration, with their efforts to mass deport people, those people are deportable and could go into the system. And so
once they're out of the country, I mean, they're out of the country.
That was Justice Sotomayor in her dissent in one of those 2, essentially said like this could moot those cases. And now you see that again with this ruling on the mass rifts that Judge Susan Ilston in California had a really, I mean, like I remember it because it came out on a Friday night when I was supposed to be on vacation, and I sat in my hotel room reading this ruling because it was like so well done and it was really complex. And she went through all of the issues about like whenever a president has wanted to reorganize the government, they've gone to Congress because that's what's needed. And this was, and Trump even did so in his first term. And this is essentially an effort with an executive order and then a joint memo from OMB and Office of Personnel Management to say, agencies, you can do mass rifts everywhere.
RIF, just so people know, reduction in force.
Yeah. And like, this is leading to, and we saw it be implemented at the State Department on Friday, was sort of the biggest immediate effect, where you had upwards of the numbers we don't even know because it was so disorganized and so informalized in a way, that I saw numbers that ranged from 1,000 to 1,300 to 3,000 people. I've definitely personally been informed of like basically entire departments that all of their senior leadership is now gone. I heard of one department where there's one person left. And this is going to upend. It's going to, like with most DOJ things, it's going to end up costing the government much more than it saves, because we're talking about long-term efforts that were in place by the government that they just like got rid of all of the people who were implementing them overnight.
So, and the issue ultimately comes down to, is a reduction in force valid? And the premise of this is we can do the agency's mission with less people. And we do this, but the tricky part is, wait, what's the agency's mission? Like, are you fundamentally altering the agency's mission? It's one thing to say the Consumer Financial Protection Bureau, it's there, and really the only thing it's supposed to do is just check on bank late fees. Everything else it does is really not part of its mission. You're rewriting what Congress has established as to why that agency exists.
What we're seeing in more of the language, and now the CFPB case, you mentioned the Consumer Financial Protection Bureau, like the CFPB case specifically, the CFPB RIF is still on appeal before the DC Circuit Court of Appeals. That was one that they did try to do individually, although it was by Russ Vogt in as the acting director of CFPB, and he's like literally the guy behind Project 2025. Yep. So we know where he wants to go with this. This is the thing that you start with the Trump's executive order that says, I want mass RIFs, go for it. You then have this joint Office of Personnel Management, Office of Management and Budget memo that tells agencies to do mass RIFs. The federal code has a provision for RIFs, like, because they understand that sometimes that's going to happen when a new administration comes in, an agency might change. But there are things within that statutory RIF process that are dealing with what you've talked about, that say, if there is statutory requirements, if there are current appropriations, which is Congress has said this money is going to this purpose, that those can't be ignored through a RIF because Congress has already decided that. And what we're seeing, what we saw with the CFPB RIF, because that was the case where we actually did look at what they did on a department level as opposed to a government level, was that there was no real individual. Like, what they showed us, what they submitted to the court was literally like an Excel spreadsheet with like how many people were in the agency, and then it moved down from like 42 to 2. And they said that would be okay. And you saw that through the entire agency. And I believe that was Judge Amy Berman Jackson at the district court sort of looked at the lawyers and were like, are you serious telling me that like this is the individualized review that the DC Circuit said was necessary? And so now you're going to see that when the Supreme Court issued their order, they thought they were being cute. And what they said is, we're just ruling on the executive order and the OMB OPM memo, and whether the plaintiffs are likely going to succeed that those were illegal. We're not ruling on the actual RIFs or the actual reorganizing plans of the agencies, which essentially said you can bring individual lawsuits, or when those get proposed, you can add them to the lawsuit and have individual things. But as we saw with the State Department, if you move quickly and implement them quickly because they've already been planned, you're going to have people out the front door before you even get to court.
All right. Lastly, let's talk about the birthright citizenship deadline. Like, just briefly characterize what the Supreme Court decided in the case that they heard. It had more to do with the power of a federal court, a subsidiary court, in constraining the U.S. government there were, I mean, it's sort of a shocking answer because, particularly in the context of birthright citizenship, because the government could just keep trying to essentially denaturalize or de-citizenify people and get away with as many as they can. And then just like, on an individual basis, people might be able to save themselves if they have enough resources. But one would think this is an action by a court. I mean, I should say by the government. Everybody is, and I think there is a judge that has ruled this, everybody is within a similarly situated class enough so that this could be a class action suit, as opposed to like a multi-district tort suit where they all suffer different injuries from a singular event. This is where everyone's going to suffer the same injury. And so he certified this as a class. What are the implications of that?
Yeah, so that, I mean, you're exactly right. The Supreme Court's order was just on this question of, I mean, Justice Barrett, in her opinion, tried to fastidiously avoid the constitutionality of the birthright citizenship executive order. And what they just said is you can't have these universal injunctions that where an individual person who sues says that this should be unconstitutional for everybody. And we can have the fight over whether that ruling was good. I think it was a bad ruling on its face. But even that ruling said there are still options in the law to get broader relief. And one of those, as you said, is class actions. And so what we have going out of that, the Supreme Court said the policy is on hold for 30 days. So apparently they're still able to have universal injunctions. Like I mean, Barrett's ruling is, to be clear, like you're going to see in the coming year, like law professors coming out with like law review articles about how nonsensical that decision was. But where we're at now, worried about people and what's going into effect, is that on July 27th, the government has said that they would be able to enforce this policy. And so Judge LaPlante issued, as you said, he did grant class-wide relief. He found that there was a class and said that that class should be protected with a preliminary injunction. And the class is essentially anybody who would be covered by the order. There's another case like that in Maryland that was the actual CASA case that had gone up to the Supreme Court. They amended their complaint to bring a class action. And then there are the two multi-state actions that were originally brought. And that was another issue that Justice Barrett said we're not resolving, is that sometimes a universal injunction isn't a universal injunction if you actually need that broad of relief in order to get your harms solved. And so the example that was before the court, New Jersey had sued, and because Pennsylvania's Attorney General is now a Republican, they didn't join the litigation. And the New Jersey Solicitor General at the Supreme Court essentially said, if you don't allow New Jersey to get nationwide relief, what you're essentially saying is that when New Jersey residents go to a Philadelphia hospital, as they often do, if a child is born there, is there going to be a debate over whether they are a U.S. citizen, if they otherwise would be covered by this executive order and are in a state that isn't covered by the injunction? And those judges are considering how to handle that and whether or not those nationwide injunctions fit. And the fact of the matter is that despite Barrett's efforts to avoid the executive order, the administration is going to appeal these things. And we are most likely going to be back at the Supreme Court sometime over the summer with another case challenging these rulings, issuing broad injunctions under the two scenarios where the Supreme Court said they could happen.
All right. So I guess we'll find out within days on that one. Lastly, 2/3. This is a broader question. 2/3, it was reported, of the DOJ, I guess, litigation unit that defends all of these policies. 69 of the roughly 110 lawyers in the federal programs branch have voluntarily left the unit since Trump's election or have announced plans to leave. Now, they're being replaced by real political cronies, but this is not stuff that you can just sort of like, you need institutional memory in there to know how to do this. And the onslaught of lawsuits against the government, combined with the lack of institutional understanding on how to handle these. I mean, even if they were all there, I think it would be difficult. And even if they all subscribed to these wackadoodle things that the administration's doing, would be overwhelming. I mean, this is like one of the, I don't want to say victory areas, but one of the areas where like the sort of the ramparts are holding a little bit.
Yeah, I mean, the federal programs branch is like the pros of of dealing with these issues. Like I've watched them in court, the long-standing ones, over the past 6 months and long before then. But I mean, these are the people who know the ins and outs. They understand the consequences of arguments. They understand the fact that you have to be very careful with arguments, because every argument on like one little thing is going to have sort of that butterfly effect, because all of a sudden it's going to become the principle, if accepted, in cases across the country, in totally different types of cases. And if all of a sudden you go from having 100 of these people who, many of whom I point out regularly on Blue Sky whenever I catch wind of somebody with more than 10 years of experience leaving, because that means that there's somebody who literally worked in DOJ throughout the entire first Trump administration and didn't leave. Like these are people who are really more dedicated to the Department of Justice than anybody else, and they're leaving. It really leads to moments where I've watched. I mean, you get these people. I mean, not to put too fine a point on it, but you get somebody who has like 5 years of experience at Jones Day or at some other big law firm coming in because one of their buddies is in the senior position at DOJ, and they literally never thought they would work in government, never planned on it, have no understanding of how the Justice Department works. They're essentially Doge employees with law degrees.
Right. Well,
with all of the disaster that entails.
Yes, but hopefully also it makes it that much harder for the administration to get to carry out and execute their plans, I guess.
Yeah, I mean, it does. I mean, you do see fewer and fewer names on the briefs in the key cases. I mean, Drew Ensign, who was the one who had argued on March 15th before Judge Boasberg in the Alien Enemies Act case. I mean, he's essentially on every immigration case now, because so many of the people within that office are gone. It's not just the federal programs branch. I mean, that's the Office of Immigration Litigation. We're seeing it in agency. I mean, like we're not even getting into like what's happened to the Civil Rights Division and stuff like that, which is both abhorrent and like will be like if and when there is a president, whoever wants to enforce civil rights law again, we're basically going to have to start from scratch.
Oy. Chris Geidner, publisher
Sorry
of
to
Law
end on a
Dork.
downer like that.
I mean, it's inevitable these days. But we will link to your Substack at Law Dork. Thanks so much for your time today. Really appreciate it.
Thanks.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.